Good afternoon to everyone. My name is Ilaria Bonomi. I'm the General Manager of the Italian Chamber of Commerce in Hong Kong and Macau. And on behalf of the Italian Chamber, welcome to everyone to this webinar on what you need to know when working with KOLs. Together with experienced lawyers from Baker McKenzie, situated both in Hong Kong and Milan offices, we will go over the tips and tricks when working with KOLs from a legal perspective. Welcome to our speakers today. We have from Baker McKenzie Hong Kong office, Lok Kun Tan, Senior Partner, Andrew Sim, Partner, and Helen Pang, Associate. Welcome. And from the Milan office, we have Davide Cascone, Junior Associate. Welcome also to you, of course. Before starting, I just want to remind to all the attendees that if they have any questions, they can write their questions in the Q&A section of the Zoom platform, so that at the end of the presentation, our speakers can answer all your questions. I will leave the floor to you, and thanks again for joining.
Thank you, Ilaria, for the introduction, and thank you, ICC, for giving us the opportunity to speak to you on working with KOLs. So as introduced, I'm Lok Kun Tan, just call me Lok. I'm the IP and Technology Partner for Hong Kong, and I'm the Asia Pacific Chair for Baker McKenzie's Consumer Goods and Retail Group. So just to set the context, in the past few years, we have seen the marketing landscape evolve dramatically as social media becomes more and more prominent and essentially inseparable from our daily lives. So while famous celebrities and movie stars were the traditional and reliable way of marketing, brands have actually been leveraging key opinion leaders, KOLs, to engage, to impact and attract customers. So the pandemic has proven to be a major opportunity for influencer marketing, as lockdowns result in customers turning to their phones and social media out of just pure boredom. To put things in perspective, the market size of influencer marketing has grown from what we were told by McKinsey reports from 1.7 billion in 2016, and today is expected to reach 13.8 billion in 2021. So there's also been a dramatic increase in the percentage of brands that have a separate budget for influencer marketing. It used to be apparently 4% in 2020, and now it's 59% in 2021. So with the pandemic, existing trends, including digitalization, have definitely been accelerated. We can therefore be sure that influencer marketing will continue to be one of the top marketing trends for brand owners. So KOLs are, usually influential individuals with an active presence on social media platforms such as Instagram, YouTube, Little Red Book, or Douyin, and they create social media worthy content for brands through the use of punchy captions, attractive photos, and in some cases, interactive and entertaining live streams. So we just wanted to show you a very short video, just a few seconds. One KOL in China, Austin Lee, is also known as the Lipstick King, with close to 40 million followers on Douyin. Not sure if any of you follow him. He once sold 15,000 lipsticks in just 5 minutes during live stream. And this is a snippet of what he does.
Oh my god！ 这是美宝莲所有的绝色口红，完全不会拔干的哑光604号色，1年4季都可以驾驭的颜色，
妖精的感觉。
王子们会涂这种颜色，特别的糯，很舒服，很美的一支橘红色，特别显肤色，白500号。
来，试完一支，还有一支。
看到李佳琦在旁边试口红，你什么样的感想？
哇，视觉盛宴，我的老板真是太好看了。
阳光青春 ，I like this one。105号，我想到了一个女明星，
这么脑海里面这么多女明星啊，
很美，买它，不要省钱。
So, oh my God, do you like that? So what is more fascinating is that they are not only human KOLs, but virtual influencers. that is influencers that are essentially created from CGI. I'm sure our speakers will be sharing more about their insights on this in a moment. The panel that we have today for you are CGR legal practitioners who will look at things that brand owners would need to know when they're working with KOLs. In particular, we'll be discussing a few things. I just wanted to draw your attention to the items. First of all, the general legal framework applicable to influencer marketing. We'll talk about some contractual pitfalls, major IP concerns in advertising campaigns, some practical tips, and how we see the future. So there's only 1 hour. We're going to squeeze as much as we can. So I'm very kindly joined by my partners and my colleagues, Andrew Sim in Hong Kong, Helen Pang in Hong Kong, Davide Casconi in Milan. So there'll be, as mentioned earlier, a Q&A at the end. Please feel free to use the chat function to ask your questions, and we'll try to address as many as we can. And if not, there'll be other ways for us to respond to you. So without much further ado, the first question I'm going to address the panel is, what is the general legal framework applicable to influencer marketing? Andrew.
Thanks, Lokun. So for China, the governing law is the advertising law. The original law was enacted in 1995, but it underwent major revisions in 2015 by nearly doubling in size in terms of the provisions, so as to take into account of the major legal trends, advertising trends that took place over the opening up of the Chinese economy. So the overall objective of the amended advertising law is geared towards consumer protection, and this is something a brand owner should always bear in mind in China. Generally speaking, China has a very broad definition of advertisement. So in Article 2, it defines advertisement as anything in which commodity dealers or service providers directly or indirectly introduce via certain media or in certain forms goods or services marketed by them. So it's very legalistic, but essentially it's a very broad provision that almost will capture any form of advertising. So in this context, KOL marketing is definitely within the scope of advertising law. So in terms of the players in the advertising law, we envisage 4 main players in the advertising context. They are the advertiser, the advertising agent, the advertising publisher, as well as the advertising endorser. So for advertiser, this is the party that designs, produces, or publishes, or appoints others to do so, an advertisement to promote its product or service. So essentially, the brand owner itself is the advertiser here. So according to the advertising law, the advertiser, which in this case is the brand owner, they will be liable for violations of the advertising law. So if any false and misleading advertisement was made, the authorities can actually take action against them. So what this means is that the advertiser is always the first target to take liability for violation of the advertising law. So even though the advertiser may have legal recourse against the advertising agent or even an endorser or KOL, the authorities would usually look towards the brand owner for legal liability. So this is something you always should bear in mind. So in the situation of KOL marketing, KOL could be both the advertisement publisher and the endorser. So it's very legalist in a sense, but it's actually quite important for the purpose of advertising law. So judging from this definition, if the KOL posts an article or a video, he or she could be seen as both the advertisement publisher and the endorser. In the situation of a live streaming event, the anchor, which is the host, is actually more like the advertisement publisher. And the celebrity that introduces the product would then be more like the endorser. So what are the key things that you should be aware of under the advertisement law? So there are certain prohibitions that and brand owners should always know. So for example, you should not make any absolute or superlative claims, such as being the best product, being the number one, or being the most productive, that kind of thing. This sort of things you should not be using in your advertisement in China. So second thing is, of course, if you make any false or misleading advertisement. So to a certain degree, there can be some advertising puff, but it must not be to the extent that it will lead to consumer confusion. So when you always make claims to your product, you should always bear that in mind. Yeah. So if you're not sure, you always should err on the side of caution by not making the claim. Thirdly, you must not do anything that damages the dignity or interest of the country or the social public order. So anything that disparages the Chinese culture should always be a no-no in China. I think you all should be aware of that. And finally, I think you should not disparage the products or services of other business operators as well. So you shouldn't do any comparative advertising of your competitors. So beside the advertising law, we also seen a lot of new advertising regulations that have been directed at live streamers. So because of the interest of time, we do not have the time to go through all of them. So I just list them one or two. One is on the Code of Conduct for Live Streaming Promotion, which is issued by the Chinese Advertising Association. And the other one is Administrative Measures for Live Streaming Marketing, which is issued by the Cyberspace Administration. So essentially, they both are in a sort of correlates to the overall objective of advertising law, that you shouldn't have any false or misleading advertisement. And secondly, the real identity of the advertiser or the endorser or the KOL in this case should always be made known to the public. So you shouldn't hide behind some other account. So that concludes for my China side.
Okay, thanks, Andrew. That's very interesting. So moving across the border, Helen, what's your perspective on the situation in Hong Kong?
Thanks, Locke. So unlike in China, there's no overarching advertising law in Hong Kong, and there are also no specific laws or regulations for influencer marketing or live streaming. So for the traders or brands, the most relevant piece of legislation is the Trade Descriptions Ordinance, or commonly referred to as the TDO. And the TDO provides the overriding principle that all trade descriptions must be true, non-misleading, and capable of being substantiated. And so that is similar to the prohibition against false and misleading advertisements in China, which Andrew mentioned. But a trade description is broadly defined under the TDO, so it doesn't only cover advertisements, and basically covers any indication with respect to the goods or services communicated through whatever means. And the TDO is, so under the TDO, it is a criminal offense for any trader to apply a false trade description or to supply or offer to supply any goods which a false trade description is applied. So a false trade description is one that is false or to a material degree or misleading. And in addition to false trade description, the TDO also regulates other behavior or commercial practices like misleading omission, which I'll come to later in a later part of this webinar, aggressive commercial practices, as well as bait advertising. And the enforcement authority is the Customs and Excise Department, and they're rather active generally in taking enforcement action against false trade description and unlawful commercial practices. Now, besides the TDO, there may also be industry or product-specific law and regulation with provisions governing advertising practices. Now, for example, drugs and medical devices are subject to the Undesirable Medical Advertisement Ordinance, which prohibits certain types of medical claims for specific diseases and conditions. And another example is the prohibition against tobacco advertising under the Smoking Public Health Ordinance. So that's the general regulatory framework in Hong Kong.
Thank you so much, Helen. So we've got in China, the advertising law mainly, and then in Hong Kong, the TDO. What about Europe, in Italy, Davide?
Thank you. What about Italy? Well, the Italian legal framework addresses influencer marketing through basically advertising law and consumer protection law again. More specifically, the main pieces of legislation are essentially two. Italian Consumer Code, which forbids any form of unfair market practice against consumers. And second one, the legislative decree against misleading and comparative advertising. Compliance with the requirements of those two laws is ensured by the Italian Competition Authority, which can issue administrative sanctions up to €5 million. And the focus of the authority over influencers started in 2017, when it sent moral suasion letters in relation to specific posts on Instagram to 7 main influencers and 11 companies selling famous brands. The letters were aimed at urging both influencers and traders to publish posts whose possible advertising nature would be clear and transparent. Moreover, in Italy, we have the Italian Advertising Self-Regulation Body, also called as EAP, which drafted the National Self-Regulation Code of Marketing Communication. This code essentially applies to all the companies and professional advertisers that accepted it by entering into an agreement with the EAP. In particular, the EAP in 2016 released the digital chart, which is now part of the EAP code, in order to regulate marketing communications and endorsement paid by influencers, KOLs, and celebrities on the internet and on social networks. So basically, the first body to concern over influencer was the EAP, immediately followed by the Italian Competition Authority.
Thank you, Davide. So just going to move to the second theme, which is to look at the contractual pitfalls when we are engaging KOLs. So sticking to you, Davide, could you start off the discussion?
Yeah, there are some key clauses when dealing with KOLs. First of all, it is essential to clearly define the subject of the sponsored content in order to determine what the company requests from the KOLs and the duration of the campaign, of course. Then, one fundamental step is to ensure the compliance of the KOL with the relevant advertising and consumer law. In essence, we recommend a warranty clause aimed at having the KOL respecting the most important requirements in terms of advertising transparency. In particular, it's quite common to require KOLs to make clear the commercial nature of the content by, for instance, means of one of the first 3 hashtags of a post, like ADV, sponsored by, or the use of the tools provided by the social media platforms. For instance, the paid partnership label on Instagram, or the use of paid product placement tool on YouTube. Also, it is important to have the KOL reviewing and complying with the code of conduct on influencer marketing and product placement of the company. Drafting such an internal code is a best practice in the Italian market. It has been recommended by the Italian Competition Authority in all its decisions on branded content so far. In order to ensure the respect of this warranty, it is advisable to consider it as something that could trigger the termination of the agreement. Whether the company relies on agency to engage KOLs, the contract shall include a clause aimed at ensuring that the agencies properly monitor KOLs' conduct accordingly. A second safeguard is to claim the right of the brand to review the content before being published. With this clause, the company is able to check if the communication style of the KOL is in line with the values of the brand and with its target. This is quite a common practice, and if you think about it, this is a way to create a deeper synergy between the KOL and the company, so that it would reflect the most appropriate language for the sponsored content. Another key clause is the so-called moral clause that prohibits certain objectionable behaviors of the KOLs. Of course, the main goal here is to avoid reputational damage for the brand, which separates its own image and its core values from the acts done by the KOL. Also, it may give the advertiser the right to terminate the contract with the KOL in case of unlawful or unseemly conduct in his private life. When negotiating the moral clause in an endorsement agreement, for instance, one of the most important issues is what kind of behavior will trigger the clause. In general, a KOL may want a short list of actions that will trigger the clause, such as a conviction on criminal charges. On the other hand, a company paying for the endorsement service may want a broadly worded clause that lets the company determine if the actions warrant termination or a fine, maybe. For instance, many influencers supporting canon movement or dismissing Black Lives Matter in 2020 had their branded contents and paid collaboration considerably reduced for this thing. Similarly, lots of companies asked KOLs for conducts in line with the government recommendation against COVID-19 spread. Other significant recommendations regard the importance of correctly managing the role of the parties in processing personal data and privacy implication of the agreement with KOLs, with particular regard in case of activities like pranks, social experiments, interviews, and something like that. Also, it is essential to clarify the allocation of liability among the parties, including any potential limitation of liability, but also remedies in case of damages caused by third parties engaged by a KOL to make the sponsored content, for instance, media producers. A final tip I would like to recommend is to consider the chance to include an exclusivity clause when sponsoring products for a specific brand. That's all from my side.
Okay, thank you. Some questions have come in, so we can address them later on. But passing first to Andrew, your take on this.
Thanks, Lukun. I broadly agree with what Davide has said just now, and I think that really applies to the China situation as well. So, but the things I would add is that in China, it's actually very important to have a written contract between the brand and the KOL. This is because the advertisement law sort of stipulate that you need to have a written contract. So even though, technically speaking, a verbal contract is in the general contract situation is enforceable, but it is not enforceable in the context of the advertisement situation. So because the advertisement law specifically provides for that. But in any case, I would say that given the onerous obligations that's imposed on the advertiser, such as the brand owner, under the advertising law, so a written contractual relationship between the brand and the KOL is actually important because it actually allows the rights and obligations of both parties to be clearly spelled out. So, for example, on confidentiality obligation, a brand owner may review some trade secrets to the KOL, and therefore, all this needs to be addressed in the contract to make sure that they don't review the thing to a competitor or to the public after that. So there could be things like the ownership rights of the KOL created content. So the KOL may be putting a post out to the Instagram or in China, it could be to Weibo or WeChat. So who owns those rights when you post those contents of the brand product? So another thing is, the things that needs to be spelled in the contract also include things like dispute resolution mechanism, and what are the remedies that are available. So if you don't have a written contract, you will actually increase the difficulty for the brands to seek recourse if things go wrong. So another thing which I want to highlight is that the contract should also set up all the parties involved. So in traditional sense, you may only be thinking between KOL and the brand. But in actual fact, if you recall from my advertising law, I mentioned that actually a lot of parties that are subject to advertising law itself. So it should, for example, not only it should include the brand, the KOL, but you should also include any third party that manages the KOL, such as the public relation agencies. So, as you all may be aware, there's this recent trend of using virtual influencers. So in this case, the creator or manager of the virtual influencers should be involved in the contract as well. And all the full names of the parties involved and for example, their identity card number should be obtained and set out in the contract. Yeah. So this is my general observation.
So just a quick question. Is it common to, for example, define the scope of what is objectionable behavior within the contract? Is it something that is...
Yes, it is actually. You can make it as a non-exhaustive list, but objectionable content could be involved in some immoral activity, or you could be, disparaging the product itself. So you can actually have a list of things to be in the contract.
So Helen, what about you? What do you think?
Yeah, so for Hong Kong, unlike in China, there's no legal requirement for written contracts. And in fact, in Hong Kong with micro influencers, so these are influencers with thousands or tens of thousands of followers and subscribers, the common pitfall appears to be exactly the lack of written contracts between the brand and PR agency on one hand and the influencer on the other hand. And oftentimes, the KOL would just provide a fee quote or issue an invoice, which will be accepted by the brand or the PR agency. And the engagement may very well be documented through just an exchange of emails or even WhatsApp messages. And we have, in fact, seen that in some of the cases that we have worked on. And this is especially the case where a lot of micro-influencers are involved and they're only remunerated with a small fixed sum of money. Brands might consider that there's a low risk of dispute and therefore choose not to negotiate or enter into a formal written contract with the micro-influencer. And from a commercial perspective, that might make a lot of sense because otherwise the brands would have to, invest a lot of resources and time to negotiate and enter contracts with the micro-influencers. So what happens if things go wrong? Now, in Hong Kong, brands or PR agencies, if they want to claim a breach of contract against the influencer, or they might very well have to rely on implied terms to establish a claim. And if it really goes to court, the outcome would depend on the court's interpretation of the party's intention. And if any implied terms are claimed, they might you might also need to look at the custom, so terms implied by custom. But again, in that case, then those terms would have to be notorious and well known in the trade. So that's the Hong Kong position.
Okay, thank you, Helen. So we're going to move to the IP section now. What major IP concerns must be considered when launching an advertising campaign with KOLs? Davide, over to you first.
Well, thank you. Intellectual property will be a thorny issue in endorsement agreements with KOLs. In fact, the first thing to care of is defining the ownership of IP rights over the contents created for the advertising campaign. We recommend companies being careful about this topic, as it's not unusual that the KOL or the agency representing him or her rather claim the ownership of the product. The IP ownership of the product. That's why whether the brand accepts the ownership of IP rights of the KOL, it must therefore implement some remedies to freely use the content. In that case, the most efficient solution, of course, is obtaining a free license from KOL to use the content worldwide, at least. On a side note, it is essential to require KOLs to provide original content, ensuring that no IP rights of third parties shall be infringed. As you may appreciate, this clause would help the brand to keep itself back from a liability in case of potential complaints from third parties. On the other hand, it is a good guarantee for the brand to have a catchy product with an original style that reflects the interests of the KOL's community and the values of the company. With this regard, let's think about a post where it's shown the trademark of a third party, for instance, another brand. In Italy, this behavior has recently been considered as an unlawful deployment of third party's trademark, and the judge condemned the stylist to pay damages for having used images where it was included a quite famous brand of another company without consent or authorization. Another slippery topic is the use of music, and hope it may reply to one of the questions already made in the chat. Having good background music can make, of course, a huge difference to the quality of a video. But be aware that videos with an appropriate use of music on social media platforms may be removed. As you may appreciate, there is a consequential damage in terms of brand reputation and the engagement of the users, which are all potential customers and will not see or interact with the content of the KOL. But it's not all. As I said before, if copyright infringing work makes a financial profit, the copyright owner will take the violator to the court. It would be within their rights to claim damages equal to the profit and legal fees. The most common and recommended remedies may be using royalty-free music, like under Creative Commons licenses, or music provided by platforms. Or use at least self-produced original music, unless you can obtain the license of the selected musical work, of course. A good example of how this topic affects the world of KOLs or content creators is live streaming. Add high-quality music to live streams can make, of course, them more engaging, but there is a high risk of infringing copyright. That's why, for example, a company like Twitch launched a tool called Soundtrack to give the ability to feature a library of fully licensed music that streamers can use within their live streams without being sanctioned. Copyright infringement may consist in violation of platform terms of use, which can ban the account of the KOL for a while or maybe forever, and therefore compromise the sponsorship agreement with the brand. That's why we strongly suggest companies to consider this issue as a key factor for allowing the termination of the agreement. It may be taken for granted, but it's not, and it may entail litigation, of course.
Thank you, Davide. Andrew, I'm sure in China, thousands of issues, but maybe just a major take on the more important ones.
Sure, thanks, Luke. What Davide said also broadly applies to China as well. So I think the only thing I would add is that when you have all this KOL content, you need to be careful. There shouldn't be any unlawful exploitation of third-party trademarks, because this can actually cause trademark infringement and also Unfair Competition Act. So Unfair Competition Act is something similar to what we call passing off in common law countries. So you may ask, what are the situations where you'll be using third-party trademark? In actual fact, I think that in a lot of countries, it's actually a very common practice whereby you do a comparative advertisement itself. So in that situation, you actually will be using your competitor's product or using your competitor's trademarks, etc. So in the context of China, we would definitely recommend not doing such comparative advertisement, because doing so, you'd be seen as taking advantage of the fame of the third-party trademark and also rewriting on the reputation of the third party as well. And also, this can constitute Unfair Competition Act under the Unfair Competition Law. One other thing which I want to mention as well is the use of third parties' name or image. So I think with KOL, this is not an issue, because in the contract you actually address on its use of its image but what if the KOL, for example, refer to a fellow KOL or use the image of a fellow KOL celebrity itself? In that sort of situation, you need to make sure that that he or she doesn't do so. And if your KOL mentioned that he or she wanted to do so, prior consent should be obtained so that the name and image can be used in advertising material, because this comes under portrait rights under the civil law, and individuals actually have a right to their own image and name, and any violations of this portrait rights can actually result in fines as well as compensation to the owner itself.
Thank you, Andrew. Sounds like the same, but with some variations. Is it same also in Hong Kong?
Thanks, Luke. Yeah, I would really just echo what Davide and Andrew said already. And similar IP issues, apply in the context of Hong Kong as well. But as I mentioned before, written contracts are rare in Hong Kong with micro-influencers. So actually these IP issues could be even more tricky without express terms. And I know that sometimes brands, they may engage production companies to do a photo shoot for the KOLs as part of the advertising campaign for a new product, or the brands may create, a deck of materials for the KOL to use. And I would just add that, in such case where the brands claim ownership, copyright ownership in the materials, they should pay more attention to the scope of licenses granted to the PR agency or the KOL to, prevent copyright infringement. Even if there's no written contract, brands should, still make it very clear that the license to the KOL is limited to the advertising campaign only.
Okay, thank you, Helen. Okay, thank you for that. And we're going to move to the next section, which is, we're trying to be practical here. What practical tips can you offer to a brand owner when they're engaging KOLs? Andrew, maybe you'll go first.
Thanks, Lo. So in terms of practical tips for China, I would concentrate on two main aspects. The KOL, himself or herself, and the contents of the advertising material. So in respect of the KOL, I would say that the brand owner should always have the true names and contact information of the KOL. It is preferable that the brand conducts background vetting of the KOL. For example, whether his or her public comments or behavior in the past was appropriate or inappropriate or is against the laws and regulations, and whether she has advertised or found to be using counterfeit or even inferior products, because this can actually impact your brand, the image of your brand when it's advertising your product. Secondly, in relation to KOL, I would say that the brand should also consider restricting the KOL from advertising or even using the competitor's product during the cooperation period. I think one good example would be Alicia Keys. She was supposed to be promoting the BlackBerry phone, but she was found to be using iPhone, and that generated a lot of negative publicity. So this is something you all should be bearing in mind as well. So in terms of the contents of the advertising material, the brand owner should proactively ensure that the contents posted by the KOL are in line with the applicable laws and regulations. It is preferable or even a must that the brand has a prior review of the advertising material posted by the KOL. If a full review is not possible, excuse me, it would be better that the brand provides a checklist or guideline to the KOL of what can be used and what is prohibited. This is actually very important because in the event that the KOL breaches any of the advertising laws and regulations, this checklist can actually provide some sort of defense to the authorities, or at least try to reduce the quantum of fines itself, because all this shows that you have engaged in mitigating strategies against the KOL. So the other thing in relation to the advertising material is that the brand should always keep track of any comments, photos, videos, and articles posted by the KOLs, and consider requesting the KOL not to delete such posts until the cooperation period ends. So in the case of a live stream, I would recommend that the brand should consider recording the live stream, so that if things go wrong, the recording would be important evidence in any administrative actions that were initiated by local authorities, or even and you can actually use such proof of the recording in any civil action against the KOL as well. The final thing I want to mention about the contents of the advertising materials is that if the authorization by KOL has a stipulated validity period, the brand should also consider whether it wants to continue using the advertising material for example, after the live streaming event for promotional purpose. You may want to maybe insert a clause in the contracts stipulating that after the event itself, you can actually use the recorded live stream for advertising purpose for X period of time. Yeah. So that would be my general tips.
I just wonder whether there's any forgiveness for any wrongdoing by KOLs, but you can hold that thought and mention it later on. But Helen, maybe before you talk about practical tips, there was a question that came in that asked about the scope. Do you want to clarify that first?
Yeah, so I mentioned that if the brands own the copyright in the materials that are to be used by the KOL, then the brand should pay more attention to the scope of license granted to the KOL. And a question arises, we just got a question about what scope was I talking about. So I think in terms of the license granting to be granted to the KOL, so it should include a right for the KOL to use, distribute or reproduce the photos or the materials on certain social media in connection with the advertising campaign. And the brands probably would not want to grant a right to the KOL to modify those materials or create derivative works of or for any purposes. So such scope should be clearly defined and made known to the KOL, even if there's no written contract in place.
Thank you, Helen. So maybe jumping there to the practical tips.
Yeah, just to add, for the practical tips, in terms of engagement structure, if multiple KOLs are involved, a brand may wish to use a PR agency, as it will be easier to manage and control the KOLs. And of course, in such case, because it's business to business, then we would expect brands to enter into a written contract with a PR agency, detailing the parties' respective rights and obligations. And sometimes, that way the agency will help shoulder some of the responsibilities. And if an agency is used, the brands can provide agency with the criteria of the KOL to ensure that the KOLs to be engaged are consistent with the intended message or of the advertising campaign, as well as the brand image. And if feasible, as mentioned by Andrew, you may also want to research into the KOL before engaging them to better understand, their background and image. And if brand typically, engages KOL directly, then it may be ideal to develop some kind of standard terms for your company for the KOL to agree to. Or as Davide mentioned, you can develop some kind of internal code of conduct for influencers. In either case, in light of the trade description ordinance in Hong Kong, brands should try to provide, where possible, a scripted caption to KOL for their use and have your legal team approve and clear the content beforehand. And if KOL is to create their own content, this could be photos and captions, then as Andrew mentioned, brands should give very clear guidelines on the do's and don'ts, and have the KOLs send a draft to the brand or the PR agency for approval in advance. So this would help reduce, the risk of the KOL inadvertently making false or misleading descriptions or statements about your products, and that increase the chance of getting caught under the TDO. And if there are any specific regulations applicable to the product being promoted, this should also be made known to the KOL and PR agency. And so for compliance, brands should also require their KOL to clearly indicate their commercial arrangement with the brands in a social media post, because otherwise this could go foul of the misleading omission offense under the trade description ordinance. And Davide mentioned this earlier in part 2. KOL can do this by using the hashtag function. And in terms of legal risk, the benefit of engaging KOL through an agency is that they may help to shoulder some of those risks, whether we're talking about potential contractual disputes with the KOL or regulatory non-compliance. For example, if something goes wrong or a KOL is found to be in breach of the terms, then a brand may hold the agency liable or make a claim against the agency. Because for reasons like enforcement difficulty or the risk of negative publicity, brands may not want to go after the individual KOLs. So that's the bit I would add.
Thanks, Helen. So Davide, I'd like to have your Euro take on this, but also a question came in. I mean, when you're doing background search, I mean, really, what are the red flags? How much can you really know anybody, right? Even from your research, but I'll hear from you.
Yeah, this is something that anticipate my topic here, because one additional thing I'd like to suggest is always considering the background of the KOL before entering into a sponsorship agreement with him or her. Knowing, first of all, his communication style, the ideas he supports in his community, and agrees, and how he interacts with his public is essential to understand if the KOL is the most suitable one for the advertising campaign. This is an asset that increases the value of the communication and the credibility of the message, and it's more consistent with the interest and expectation of the target. Of course, this ensures a higher level of engagement in the community of the KOL. A second point I would like to suggest is having and keeping your dedicated personnel well-trained about this topic. We all know how strategic is this kind of communication in the advertising market, and any breach of the law or legal practices may lead to higher risks in terms of not only administrative sanctions, but most of all, brand reputation. In fact, the resonance of this kind of communication and any relevant legal issue in implementing it can sway the reputation of a company in one direction or in the other, with a strong impact in terms of consumer engagement. Also, this is a topic which is even more under the attention of the European regulators. For example, I would like to mention that the UK authority has condemned the use of misleading beauty filters to promote skincare or cosmetics. And a new law in Norway is coming into force that will mean social media influencers can post modified photos without declaring what they've done. It's easy to understand how much it will affect the monitoring of paid posts.
Thank you, Davide. So we have one last question. We hope we can get through all of this. I will ask for your forbearance if we just go a little slightly over. So we're going to do a bit of future watch here. So Helen, first with you, how do you see influencer marketing in the future?
Thanks, Luke. So for the market generally, I think that influencer marketing is definitely here to stay. I think growth will continue given this is really the overall trend globally, as well as, given the various benefits of influencer marketing, in particular, the high engagement with brands' prospective customers. And brands can also appreciate that the impact and reach can be monitored and quantified using the various insight tools that the social media platforms provide. And they can also quickly see and identify, the reaction and feedback from their prospective customers. For Hong Kong, live streaming and virtual influencers are not as big as in China, but it's slowly picking up. And given the prospective growth, I think that, brands may also start developing longer-term relationship with KOL instead of, sporadic engagement with a wide range of KOL. Brands might consider developing a more sustainable partnership-like relationship with certain KOLs. By, for example, giving some training to the KOL, and really brands want to grow with the KOL. So this will allow brands to work more closely and effectively with their KOLs, so they become kind of like a mini ambassador. The benefits of this is that the image of the KOL can be aligned with the brand image, and also it's likely going to create a more sustainable impact on the KOL's followers. In terms of regulatory framework in Hong Kong, at least, there's nothing in the legislative agenda right now, and it's unlikely that there will be any specific laws or regulations targeted at influencer marketing. To protect consumers, the Trade Description Ordinance is broad enough to cover the commercial activities of the KOL insofar that they relate to the brand's products or services. And there are also other industry or product-specific regulations. Hong Kong law embraces the principle of freedom of contract, so that will continue to allow businesses and KOLs to negotiate their own commercial arrangement. But I think over time, some form of customary or local practice will be developed in Hong Kong. And if a dispute ever arises, those customary practices might be useful in common law to imply terms into a contract.
Great, thank you, Helen. Andrew?
Thanks, Lo. So for China, I would say in terms of the future of influencer marketing, we will see a growing phenomenon of the virtual influencers. This is something I've already touched before in my previous presentation. So I think to a lot of you, I think you all will know what a virtual influencer, but essentially it's actually a computer-generated fictional character that's used in social media marketing. So it is we have seen in instances whereby in China at least that brands are actually eager to partner with virtual influencers for the marketing activity. So for example, during last year's Double 11 or Singles Shopping Festival, we have seen Philips, L'Oreal, Unilever, and L'Occitane all use virtual hosts in the product promotions in live streaming events. So, and also last year, we also in May 2020, we also seen a virtual influencer called Luo Tianyi with others, and she actually alongside with other virtual idols hosted a live stream show on Taobao, which attracted 2.7 million viewers in China. And she has since partnered with brands such as Pizza Hut, KFC, or L'Occitane. And she herself, being a virtual influencer, have over 5 million Weibo followers. So Weibo is the Twitter equivalent in China. So another example of virtual influencers is called Nunuri, which is created by Jörg Zuber, which is a Munich-based graphic designer. So and it was created for Vogue China, and is actually a brand ambassador on Tmall luxury pavilion as well. So it means all this means is that when you deal with virtual influencers, which I mentioned before, always make sure that you should include the creator of the virtual influencer as part of your contractual negotiations, and they should always be part of it to make sure that they are involved in the matter. That's it.
Thank you, Andrew. David, any additional trends to add to this list?
Yeah, just 3 short trends I would like to talk about. The first one is short videos, around 15 seconds, no more, that have been extremely popular so far and will most likely be no different in the future. Let's think about not only stories, but also TikToks and Instagram Reels. Given the challenges of creating traditional length video content, the need for viral trends and time-sensitive messaging is essential to catch the attention of the users and get a higher interaction with the community within the social media platform. A second key topic is taking a stand. In light of the recent facts affecting sensitive topics like racism, gender equality, and climate change, more consumers than ever are demanding that business speak up on topics like this. However, it's not enough for a brand to issue a statement or even promote a donation. Many consumers today are looking to support the brands that put real action behind their stated values. As said before, this is an additional driver when selecting KOL for your advertising campaign. In the past, most brands have largely avoided hot-button political and social justice topics, but this is no longer a safe bet. Silence may be seen as complicity, let's say. The last trend I'd like to flag is the booming of live streaming, as already Helen and Andrew talked about before. The pandemic played a big role in increasing live streaming, as mostly offline activities were suspended. This trend has exploded in China, where many merchants turned to live stream, resulting in the largest online live sales in the country as ever seen during the quarantine. Therefore, the demand for live streaming talents boomed. The best case study would be Taobao, where merchant promotes their business through live broadcasting. And when customers click the link on the product or e-store, they can browse pictures, watch try-on videos, or catch live streams. So they now have more ways to interact with brands and are engaged for longer periods of time. In this context, of course, KOLs are the best resource for vendors, as they have the ability to appeal a significant number of fans and potential consumers.
Thank you, David. So now we are onto the Q&A, and we've got an interesting question about product seedling. And KOLs are not asked to post comments, but if they do, what is the situation, Helen? How would you like to address that?
Yeah, so in that case, it seems like there is not really a contractual relationship between the brands and the KOL, but the very reason for the brand to provide those free products to the KOL is hoping that they would, put it on their social media, and so to promote those goods. And so to avoid the risk of getting caught for misleading omissions under the TDO, we would still suggest that the KOL, identify that the products have been provided by the brand or for free, and do it, and they can just do this using a hashtag, and that would reduce the risk of falling foul of TDO. So that's the Hong Kong position.
Thank you. So I had a question earlier on about what's the difference between celebrity, contracts and KOL contracts. Would any of you like to address that? Is there a big difference? I mean, are KOLs just like mini celebrities or future celebrities?
If I can say something about that, I think that the substantial difference here is the medium and the form of communication, first of all. That's why the main thing here is to ensure the transparency of the commercial nature of the content. That is the most important thing that has concerned the regulator so far. So my suggestion and in my view, the main difference in these two kind of sponsorship agreements is to be aware of how to ensure that the transparency of the commercial nature of the message is provided.
Maybe I can add something to that. Apart from what Davide said, I would say that the difference in the context, in this context, is celebrities, movie stars do not do live streaming shows. So that would be the big difference. Because I think if you have seen instances whereby they do all this placement shows itself, the perceived value of the brand, of the celebrity brand, will go down, because this is seen as a cheap form of watering down of their brand. So a lot of celebrities will not do that. So for live streaming, which is the way going forward, we tend to see more of specialized hosts who are actually specialized in this area itself. Yeah. So that would be my main takeaway.
Okay, there's a question that came in on how would you balance complacency and controversy. So I think for me, it could be answered in various ways, but I'd like to hear from you guys. I mean, in terms of the behavior of the KOL, are they sometimes being inadvertently complacent, or are they deliberately attracting controversy? So there's that balance that needs to be managed. I suppose that's what the question is asking, but if not, if I'm wrong, please text me and let me know. Does any of you want to answer this? How careful can we be?
I think for it's hard to control the behavior of the KOLs itself. So that's why I think we mentioned before, Davide, Helen, and myself before, if possible, especially in relation to your product branding and advertisement, right? You should have sort of a general code of conduct, the do's and don'ts, because that not only will help to protect the brand image, but also help you to, in the event that anything goes wrong and the local authorities come to look towards you for legal responsibility, you at least have the code of conduct to protect yourself to some extent.
I suppose virtual ones would be easier to control.
Yes.
Yeah,
that's right.
So I'm afraid we have reached the end of the line here, and we have to leave the session soon. But maybe before we end, just one sound bite from each of you, starting with Davide. Thank you for calling in from Milan. Let's hear from you. What are your parting shots here?
Thank you.
Davide, can you hear me?
Yeah. Okay.
Just your soundbite, your final goodbye message.
Sorry. Also, thank you for inviting me from joining this session. I think it's quite a hot topic and very interesting to deal with. So thank you for having me here.
Andrew?
My parting shot, in relation to KOL, I would say it's a hard thing to do, but you need to control your KOL for your brand product. Otherwise, a lot of things can go wrong, especially in live streaming. So do whatever you can, even though the KOL may resist. Just make sure that you do to the best of your ability to control that.
So Helen?
Yeah, so influencer marketing is definitely here to stay. So like Andrew said, if possible, try to make sure you do it right.
Okay, thank you. And for me, I'd just like to thank all of you for taking part in this webinar. I hope you found it practical and useful. Obviously, the conversation doesn't end here. And if you have additional questions, obviously do contact us in some form or other. We want, on behalf of Baker McKenzie, want to thank ICC for this amazing opportunity to talk about KOLs and other related topics. And thank you very much for attending. Stay safe, everyone, and thank you very much.
Thank you very much for this insightful discussion. Thank you to our speakers. I would like just to remind to all the attendees that we're going to send a survey right after the end of this webinar. So I invite all of you to complete the survey. And for those who wants to have the recording of this presentation, or if you have any additional questions, feel free to contact directly the speakers, or you can send an email to us to icc@icc.org.hk, and we can put you directly in contact with the speakers so they can send you the recording and answer all your questions if you have any additional. Thank you again, and stay safe, everyone.
Goodbye.
Thank you. Bye.
Goodbye.